Good morning again from the Center for Digital Ethics and Policy International Symposium. My name is Florence Chi. I serve as director of the center, and it's my pleasure to welcome you to the second session of the morning, which is copyright and AI. Joining us today, we have Meera Nair, who's the copyright officer of the Northern Alberta Institute of Technology, and Margaret Heller, who's the digital services librarian at Loyola University Chicago. We will start off with Dr. Meera Nair's presentation, AI and Getty Images, a complicated relationship with ethics. Meera Nair holds a doctorate in communication with a research interest in systems of copyright, both historical and contemporary. Prior to that pursuit, a Bachelor of Science in Mathematics had led her to the IT sector for 10 years. Most of that time as a small business owner engaged in consulting for technology transfer projects. Currently serving as copyright specialist for the Northern Alberta Institute of Technology, she speaks regularly about the intersection of copyright, creativity, and innovation. These themes are fodder for her blog, fairduty.wordpress.com. One of her claims to fame is that Commander Chris Hadfield once tweeted out her work. See the link online. Thank you very much. Please take it away, Dr. Nair.
Chris Hadfield is our Canadian contribution to astronauts. I mean, we've had many, but it was quite a day when I discovered my work in his tweet stream. So I just figured it's the best calling card I will ever get. Anyway, good morning, everyone, and thank you very much for having me here today. I've been watching the work of the center for some time, and it is a great privilege to be able to contribute to your gathering in person after 3 years of some isolation. One aspect about copyright that I find both fascinating, I'm supposed to be the mic, right? Okay, one aspect about copyright that I find alternately fascinating and frustrating is that what it is in the popular imagination does not always match. In fact, most often it doesn't match to what it is as a legal standard. To the average person, copyright registers as a grant of absolute control, that you cannot use even a scrap of someone's content without asking permission or possibly, making payment. Whereas the reality is that copyright has never functioned that way. Since its inception in modern law over 300 years ago, there has always been some space for unauthorized use. But what I find quite intriguing, and actually I was speaking to AI computer science developers at one point, even among those who are aware of the structural design of the law, that it is a set of limited rights, there is still unease about using other people's work. As one person said, it just feels unethical. And that is what I wanted to tease out a little bit today. Now, when I submitted my proposal, I had a plan. It was about Getty Images, the lawsuit they are bringing about the use of their materials in, AI programs. And then when I sat down to actually write it, it turned into something else. So what it turned into was A Tale of Two Gettys, a play in 3 acts. And the reason for that is that if you are going to have a discussion about Getty Images and copyright and ethics, there are 2 stories to be told. So in the present state, the complaint that is before the courts right now, Getty plays the part of the wronged party. It is the entity that is stewarding the work of many, many thousands of individual photographers and artists in an effort to try to raise some income for them, at least periodically. But in a prior tale, Getty Images is cast as the villain. It was that very callous corporate entity that did an artist out of perhaps 2 of her most precious possessions, her own identity and her reputation. So 2 tales laden with emotion, copyright, and appeals to ethics. So beginning this play, Act 1 is situated in a courtroom. Imagine the lawyers for each party on the opposite sides. And the lawyers for Getty Images would rise and state their complaint. And they don't stint on adjectives laden with emotion. They will tell everybody that this case arises from Stability AI's brazen infringement of Getty Images' intellectual property on a staggering scale. That Stability AI has copied more than 12 million photographs from the Getty Images collection, and the italics were in the original document. They will also complain that Stability AI has removed or altered Getty Images' copyright management information. And they will point out that many of these images are licensed to Getty for distribution, and they are the creation of hundreds of thousands of contributing photographers who rely on the licensing income Getty Images generates for them. Well, the gauntlet's been thrown down. With great flourish, the lawyers for Getty Images will produce their Exhibit A. It's pretty damning evidence. The image on the left is one from the Getty Images collection, complete with its watermark. The image on the right was created by Stable Diffusion, replete with a rather mangled, recreation of the Getty Images watermark. And so the lawyers will go on and say that Stable Diffusion at times produces images that are highly similar to and derivative of. Okay, those are big flags in the world of copyright, similarity and derivative of Getty Images' proprietary content. And then they pull out their trump card that independent researchers have observed that Stable Diffusion sometimes memorizes and regenerates specific images that were used to train the model. This again is another huge flag, because this may be all they need for the win. In any conventional understanding of what memory and memorization mean, we have this idea that we have experienced a work, whether it was music, art, or literature, and then stored it somewhere between our ears, that we are very conscious of having, if we will, copied that information into our own consciousness. And that is, the first step towards a claim of infringement. And Getty's lawyers may very well point out that memory has led to infringement in numerous cases, and in particular in the world of music. That in fact, it wasn't even conscious memory. It was enough to have unconscious memory of a strain of music that has landed more than a few follow-on musical composers, in the copyright infringement suit. And so those lawyers might point to, there's a variety of cases to choose from, but these three might stand out. The first time it happened, oh, by the way, these are not the case names. These are the names of the songs that were in contention with each other. The first time this happened in the United States was in 1924, where a popular song known as Dardanella had been, received a lot of attention. And a few years later, composer Jerome Kern writes his own song, Kahlua, which includes an 8-note pattern that was traced back to Dardanella. And the presiding judge, who had this wonderful name, Judge Learned Hand, I thought that's beautifully appropriate to the legal history, makes a point of saying that everything registers somewhere in our memory. Okay, no one can tell what might evoke it. And the judge was very sympathetic that Jerome Kern did not mean to plagiarize the music, that this was not intentional. There was nothing malicious about it. But that fact was not enough to escape a charge of copyright infringement. Because as far as the judge is concerned, it does not matter. The author's copyright does not depend upon the infringer's good faith. Once it appears that another has in fact used the copyright as the source of his production, he has invaded the author's rights. And it is no excuse that in doing so, his memory has played him a trick. No excuse, okay? Those words would carry a lot of weight in subsequent music cases. And among, again, the notable ones, about 50 years later, George Harrison's composition, My Sweet Lord, runs up against He's So Fine, which had been written by Ronnie Mack and popularized by the version sung by the Chiffons. Now, in the case, George Harrison describes in detail how he went about composing the song, that in fact, he was working with a gospel singer, Billy Preston. They had first worked independently and then kind of pooled their ideas. As far as Harrison's independent effort went, he started off just by singing the phrases, Hallelujah and Hare Krishna, and tried some guitar improvisation. And so again, while the copying was recognized as being unintentional, the presiding judge, Judge Owen, was still insistent that, again, this is copying, therefore it is infringement. And he even went so far as to say that that strain of that tune, Harrison may have been particularly inclined to, that his subconscious mind knew it had already been successful because it had featured in a very popular song. And then about 25 years after that, another collision of songs in a court. And this time, the title was the same, Love is a Wonderful Thing. The title was not the problem. Again, it was the content, the melody of the song. And this one went to a court of appeals where a lot hinged on the fact that the first version of the song, which was created by the Isley Brothers in 1966, had received a lot of airtime. It had been very popular. Apparently, they had some DJs come in and testify about how often they played that music. And it was deemed that teenage Michael Bolton had heard it, internalized it, and then brought it out to bear when he created his own song, Love is a Wonderful Thing, in 1991. So, a 25-year gap between these events, but it was still enough for him to be charged with infringement. Because where the court went with this was that sort of famous wording, that substantial similarity is linked to the issue of access. If you had access to the work, you have more likelihood of coming up with something that is substantially similar. And so what they described was their inverse ratio rule, that you can have a lower standard of proof if there was a high degree of access. Well, coming back to the case of Act One, and that is the current dispute between Getty Images and Stability AI, Getty's lawyers will point out that we're not even talking about degrees of access. Access has been fully conceded because the program, Stable Diffusion, was trained on those images. So we do not even have to guess at the question of access. That will be their argument. And the lawyers are likely to plead with the court that, are we really going to give a machine more consideration, more latitude than what has been expected of human musicians for the last 99 years? They will wonder, where is our ethical compass? Are we really going to go down that route? And that will be Act One. Now, the lawyers for Stability AI have a difficult journey ahead, because they not only have to persuade people that the program is operating within the parameters of copyright law, but they also have to move this ethical argument, or at the very least, they have to try. So when they rise to speak, they will point to a lot of American history, starting with your constitutional imperative as to why do you even have a system of copyright? It had very clearly defined goals. It was to promote intellectual activity, the progress of science and the useful arts. That was where this began in the late 18th century. And since then, systematically, the United States has this wonderful track record of showing how new media development has always thrived in those spaces that were unprotected by copyright. And one of the people to read, I hope they will cite, is Jessica Littman, University of Michigan Law. And she wrote this wonderful book in 2006 called Digital Copyright. It was later re-released under a Creative Commons license. And she details where, from the player piano to the radio, VCRs to the personal computer, that ability to use prior content is what has fueled innovation. The lawyers should also point to Fred von Lohman, who at one point was, I think, a general counsel at Google, although I could be mistaken about that. Anyway, he wrote a really wonderful piece about unauthorized use under your condition of fair use. And he showed the honor of permitting unauthorized use. And what he wrote at the time was, to the extent it permits private copying, fair use creates incentives for technology companies to build innovative new products that enable such copying. Far from being an unfair subsidy from copyright owners to technology innovators, this aspect of fair use has yielded complementary technologies that enhance the value of copyrighted works. The lawyers might also want to point out that the American system of fair use is the envy of nations around the world. That in fact, about 12 years ago, then UK Prime Minister David Cameron actually commissioned a review to see, and I quote, whether their IP framework was fit for the internet age. They explicitly wanted to identify how the US had this, near unbroken track record of success. And fair use was singled out as the mechanism by which American companies, name dropping Google here, were building dynamic new businesses on the internet. And it's entirely possible that those lawyers might point to the work of Matthew Saag, who until I think sometime last year was a member of the law faculty here at Loyola Chicago, who is one of the principal experts in the country on the issue of fair use, text and data mining, and how one manages that balance. And through his work, what he has pointed to in through various case law is that when you are copying expressive works for non-expressive purposes, that is justified as fair use. That is where your courts have taken you. And this is a significant issue for the legality of works that are training, AI programs through existing content, because the content is deconstructed. It's not perceived in its form that the individual human will encounter. It is literally turned into a collection of information about that expressive expression. So with all that, of history, the lawyers might still want to point out that, yes, this is contentious. We know that every single time that a new media has been developed, existing content owners have been very unhappy, to a point of hostility. And they may very well want to point to what was possibly the most epic battle in 20th century American media development, and that was the creation of the video cassette recorder. The film industry was convinced that this would be their death knell, that everybody from actors, screenwriters to the people working on the sets, the entire industry was in jeopardy. That was their argument. Well, I mean, some of the language used at the time was, bordering on hyperbole. The president of the American Motion Picture Association of America at the time, a man by name of Jack Valenti, compared the VCR to the Boston Strangler. He was trying to get Congress to declare, to prohibit the technology. It didn't work. The film industry also sought to bring this to the courts through all three levels, made it to the Supreme Court of the United States, wanting it to be declared, infringing technology. Your Supreme Court said no, because the technology could be used for non-infringing purposes. And what's really quite telling, as was reported by the Chicago Tribune, a little over a year after that Supreme Court win, is that the film industry was now showing record profits. They were earning as much as they did at the box office from video cassettes. 1.5 billion was their take through the year of 1985. And that was at a time when VCRs were not yet prolific across the entire nation. So knowing that that was coming, this was nothing but good news as far as the coffers of the film industry were going. So the history is helpful, one would hope, that in a court of law, placing things in context, having a better understanding of the big picture, you hope that that brings people to a better understanding of the issues. But there is still this perception out there that Stable Diffusion, or Stability AI, and then through its program Stable Diffusion, has just gone about hoovering up information and is then recreating it at will. So the lawyers might want to point out their own exhibit. Eric Wallace is one of the researchers that was, from that study that was mentioned before. And he's very direct about what memorization means for them. I mean, there's a reason why in their paper they put quotations around it. As they say, to begin, we propose and implement new definitions of memorization in image works. And what they've actually characterized memorization is that's what happened if the program has generated a near exact copy, which is somewhat turning on its head the idea of memory as it has been used so far just in our own sort of understanding of what goes on between our ears, and even in terms of what the courts have said. They will probably bring in their own experts to explain that art generating AI programs do not store the training images. This is not about some wildly new, technique of compression. Instead, again, those images are just deconstructed. You learn about what was in the image by the information of the image. Much like a child might start to draw, you ask a child to draw a house, they'll begin with a square and they'll stick a triangle on top, because that's what they know a house has. It has a body and it has a roof. It is through the bulk force of computing power that image generation is able to happen without ever actually comprehending, seeing the image itself. But the lawyers will be aware that these technical facts, while they are important, still not likely to sway the ethical appeal, that aura of artists' work being stolen, being misused, being used in profitable ways with no money coming back to them. So Stability AI's lawyers are going to try to change that conversation. And so perhaps with their own dramatic flourish, they're going to say people who live in glass houses really shouldn't throw stones, and they'll offer up 2 words, and those words will be Carol Highsmith. Carol Highsmith is a well-known and highly respected, regarded American photographer. Many decades ago, I think starting in the sort of late 20th century, she began donating her work to the Library of Congress, all of it. And then, of course, as digital technology set in, it became even easier. Even more of her work was started arriving at a much faster clip. And her intention was that her photography should be easily accessible and available free of charge to every American. At the time, the Library of Congress called it, one of the greatest acts of generosity in the nation's history. Now, all seemed to go as planned until one day when Carol Highsmith received a bill for one of her own photographs used on her own website. And the photograph had come courtesy of Getty Images and one of its partners. They had scooped up her material and were licensing it. So she filed a lawsuit and pointed out that, as the details, were revealed in that day in court and through all the documents, an express condition of her offer to the Library of Congress or to anyone who was using the photographs is that her name had to stay on them. It had to be identified that she gave this to the American people. Said another way, when Getty Images stripped out that vital detail, they had tampered with the copyright management information. She also remarked that her reputation was being sullied. Users who had obtained her material from the Library of Congress site then received a bill, and they're floored and angry. This woman apparently gives it away and then sends a flunky out, with an invoice. It did not reflect well on Carol Highsmith. And at its core, it was no longer her work. Nobody would know that she had taken those pictures. Now, Stability AI's lawyers will give the sad ending of this story, that Highsmith lost the case, because it seems that at the time, the judge had agreed with the position taken by Getty Images, that when she donated her work, she lost control of her work, that putting something in the public domain meant that you no longer have any control over how it is used or how it is referenced. Now, I have to say, even for the late 20th century, I think there is more nuance to the system of copyright as it was practiced in the United States and other places. I did not find that a compelling argument, but at the end of the day, Getty Images won. So it's somewhat interesting that what I think everybody would agree was a huge lapse of ethical conduct. If it's allowed, if the system of copyright will allow it, Getty Images and others seem to be quite okay with it. So to turn around now and suggest that the use of their work for AI training is an ethical lapse that the copyright system permits, but should not permit, it seems more than a little bit hypocritical. So Act 3, the judge will no doubt have questions for both parties, is confused, possibly perplexed. Because right now where we are sitting at, it does feel like the scale of activity of artificial intelligence, the acceleration of that development is unlike anything we've ever seen before. And somebody on the floor might want to be quoting James Grimmelman, who is another highly respected IP voice in the United States. And he said, "I'm more unsettled than I've ever been about whether the training is fair use in cases where AIs are producing outputs that could compete with the original." This is a big point for fair use. Getty Images will likely say, there's a compromise here. You can use our work, you just have to pay us for it. What we need is just a collective license and all will be good. Stability AI is going to point out that collective licensing is a burden. And I got to tell you, look at Canada, you'll find out just how much so. And it's expensive. And this is a big point because you're talking about training on millions of artifacts. Okay, only a handful of companies will be able to afford this. This is going to skew the development process. Who gets to participate in the new media developments to come? And they will say that this is contrary to American policy since 1790. It is not a step to be taken lightly. And I do feel that, to bring it to the theme of your conference, that this is the inflection point. And ideally, they will point to the work of Zarina Khan, who is a phenomenal economist. And for over 20 years, she has focused in closely on the big question: how is it that the United States made such an extraordinary leap in less than 1 century when it declared itself a new nation, that it went from a fairly, if you'll forgive me, backward agrarian society to overtaking the former giants of the day, that is England, France, and Germany. And they did it in less than 1 century. And Zarina Khan will very much tie this to, it was the way the United States sought to encourage intellectual property development. The old world had based all their IP incentives pretty much on their class system. It was intended for the upper echelons of society, the people who had been to the right schools, who had enough money for the patent filing. That was where they set their sights on intellectual effort. The United States at the time set it very firmly on every individual. They really democratized the process of creativity and innovation. And the proof is in the pudding as to what they achieved over, within the space of a century. So with that, the judge decides to reserve his decision, and we will sit and wait to discover how this plays out. Thank you very much.